Good morning. For those of you just joining us, we'll get started here in about 2 minutes. Good morning and welcome to the Niskanen Center briefing on copyright during the pandemic. I'm Kodiak Kildavis, the Director of Government Affairs at Niskanen Center, and it's my pleasure to be moderating today's discussion. As a reminder, there's a Q&A feature at the bottom of your screens and also a chat function, and we encourage all attendees to submit questions throughout the discussion, and then our panelists will answer those questions at the end, time providing. It is my pleasure to introduce our panelists for this morning's discussion, Daniel Takish and Meredith Rose. Daniel is a regulatory policy fellow at Niskanen, where he manages the Captured Economy Project. His areas of expertise include intellectual property, occupational licensing, regressive regulatory policy, and Meredith is senior legal counsel at Public Knowledge, an organization dedicated to an open internet, freedom of expression, and access to affordable information. Meredith holds a JD from the University of Chicago, and her area of expertise are copyright, DCMA, intellectual property, and governance. Today's conversation will focus on the intersection of copyright law, property, and the digital world. Daniel and Meredith will talk us through considering copyright as property, how digital space requires different approaches, and regulatory challenges. So without further ado, it's my pleasure to hand it over to Daniel Takish.
Thank you, Kodiak, and thank you to everyone who's able to be with us. So to start out, I'd like to address the general Niskanen Center framework for how we view copyright. Because while it definitely belongs, or at least is referred to in the general family of intellectual property, and while it's perfectly fine as a shorthand, we think it's a mistake to view copyright as a form of property, and more importantly, of deserving the same moral protection that one would give to property rights as they would in the physical world for land or personal possessions or things like that. We think this has important implications for the general debate, because if you are going to restrict someone's property rights or give someone else access to use property, that requires a significant justification, and you have to treat that very carefully, not just for legal reasons, but also morally as well. Whereas if you view copyright not as a species of property, but rather as a subsidy or regulatory privilege, then that means there are significantly more degrees of freedom available to policymakers in terms of setting what copyright looks like, how much, if any, of a given work that you can use. So it's important to shift the conversation from this is a property right which must be protected to this is a regulatory policy which we can tweak depending on which produces the best outcome. So why do we not believe that copyright is property? There are two main justifications for why copyright is property, and we think both fail. First comes from the law and economics tradition, and this is best argued by Harold Demsetz in his paper Towards a Theory of Property Rights, where essentially, excuse me, he argues that in the case of land, he uses the example of Native American tribes in present-day Canada, and even though the example is historically suspect, the general argument holds, where he says, if you have a population of beavers for which the pelts are hunted, if we have no property rights, no exclusive claim over a territory, then we'll run into issues related to the tragedy of the commons, where they will be hunted to extinction and then nobody can enjoy them. Whereas if you divide up parcels of land so they can be efficiently managed, then in that case, everyone will have an incentive to maintain and keep the population as a whole. This makes sense in the world of physical property, where there is scarcity which must be managed. But fundamentally speaking, ideal objects such as those embodied in copyright are not scarce. And when we grant copyright to an ideal object, be it a book, or at least the content of a book, a song, a movie, what have you, what we are doing is artificially creating scarcity. And while it may be true on the margins that the ability to internalize the gains from the production of a given ideal object incentivizes its production, similar to the efficient management of physical property, this disconnect between the rivalrous nature of physical property and the non-rivalrous nature of intellectual property makes it so that those concerns of scarcity are much less relevant. I could copy a book, and even though that would be copyright infringement, it does not harm anyone else's ability to enjoy that book at the same time. So that is the law and economics justification, and it fails largely because the nature of intellectual property and the nature of physical property are so different that the analogy doesn't carry over. It's a category error. But the law and economics justification, as clever as it is, doesn't have a lot of moral passion to it, which leads us to the second main justification for the treatment of copyright as property, and that's what we'll call the Lockean justification, where we believe people have the right to the fruits of their labor. This has significant moral appeal, and again, this is why it's important to differentiate it from physical property rights. And while people do put significant effort into their works, and we think as a matter of policy, it is probably a good idea to secure for individuals the right to their copy, the right to the work, and the prevention of de minimis changes and things like that. The problem with the Lockean theory is that it proves too much. There are various works which are not protected by copyright law simply as a matter of policy for the sake of efficiency, or because it would give someone a monopoly over an idea which cannot be protected by copyright, even if it is new, even if someone put a significant effort into it, over a specific expression which someone also put work into. So the fundamental issue with the Lockean justification is that it proves too much and it goes too far. And most importantly, unlike the classic case of someone going into a virgin wilderness and tilling the land and making it theirs, and appropriating, from nature, the nature of ideal objects in the case of intellectual property and copyright is that there is so much borrowing that is fundamental to the process. We all take things from the world when we're creating our creative works. There's a lot of re-implementation and borrowing that's inherent to the process. And for that, I'll turn it over to Meredith, who can do a much better job explaining the nature of that borrowing and re-implementation than I could.
Yeah, so a couple of things that I want to, and I apologize, it doesn't flow directly, but sort of a couple of things to keep in mind. As Dan pointed out, one of the problems with copyright is that it too often devolves into an existential question when you're discussing originality in particular, because copyright adheres only to original works of authorship under the statute. And then the question becomes, how do you define original? And then you get into problems of, well, something built upon something else, so you only get protection for the new original parts. And how do you slice those? And as a practical matter, this turns every judge into a literary critic or an art critic, which, they are occasionally very happy to perform and often think very highly of themselves when doing it. But it requires you to get to the sort of atomization issue of how do you suss out original, and then how do you suss out expression, which gets to be a problem when you start talking about things like computer code, which is inherently just a series of instructions that you're feeding to a machine to tell it to do certain things. But Congress and many commentators agree that computer code should receive copyright protections for policy reasons. And then you have to get down to the question of how do you define computer code as creative? One of the things that I would like to flag as a practical level, sort of what has gotten us here, is that copyright law was fundamentally designed for physical goods. Historically, it has always been rooted in physical goods. There's a very long streak in copyright law that says you may not copyright an idea, an abstract thing, partly just for a burden of proof issue. You cannot prove that you had this idea first, or that you uttered something and another person came along and copied it from you. I think there was a very realistic proposition that people said, look, we can't adjudicate that functionally. And so it's an original work of authorship fixed in a tangible medium of expression. So it has to be written down, has to be photographed, has to be printed, has to be recorded. The trick there is that tangibility has always been, and the existence of physical copies has always been a turning point for copyright law, which means that copyright law had something of an identity crisis when confronted with digital media. Digital media is different from physical in a bunch of ways, much in the way that sort of abstract ideas are different from land, as Dan went into. But one of the key things is, in order for digital media to be covered under the copyright statute, we had to find a kind of clever legal fiction by which we can say that a digital file is a physical copy, that they are the same thing. And basically, Congress and the courts worked themselves into a corner with this. So they created the legal fiction that the particular, without getting too into detail, the very short version is that the particular micron of hard disk space that a file occupied is considered the physical copy. And every time that file moves from one micron of disk space to another, that's a reproduction or a distribution or a copy. But we created this myth of having the physical copy being embodied on a specific hard drive. And this obviously starts to break down. Anybody who spent enough time with computers knows that this breaks down very rapidly, because even something as simple as rearranging your file structure then impermissibly copies and then deletes copies. And so this creates all kinds of cascade effects. And this is really, I just want to mention it because it's really the core of the problems that we have had when talking about digital media and shoehorning digital copies into the extant copyright system. From a policy perspective, there are other issues. Physical media is essentially like a book. If I read a book, that book is now, if I buy a book or if I take that book out of a library, that's a physical copy that is now no longer available to others. If I have it exclusively for a period of time, then I have to share that physical book with someone else. There is none of that scarcity in a digital sense. They can be reproduced almost instantaneously, infinitely. And so you have to find a way to artificially impose that physical scarcity on a digital copy in order to maintain the sort of underlying economic principle that justifies copyright law, which is that things are easy to replicate, and we need to ensure that there's some kind of scarcity that we put on them, so that there's some economic incentive. So scarcity creates economic flows, which go back to the person who created it, and that makes sure that we have an incentive for further creation. And so the original problem of basically Gutenberg's printing press is all of a sudden reproduced on steroids, where now it's not just any Printers Guild with a printing press can reproduce a copy of a book. It's just anybody with an iPhone in their pocket can reproduce, 20 million copies of this thing in an hour. And so it becomes a big problem. One of the problems sort of that this has led to, through a combination of our sort of badly bootstrapped attempt to move copyright into digital, is that a lot of the traditional protections that have existed for users, for certain kinds of institutions like educational institutions, libraries, et cetera, have gone by the wayside. They have been sort of subordinated to this primary motive of creating and maintaining scarcity and they have become sort of an afterthought. So, for example, libraries have their own section of the copyright law that they are protected under. It gives them sort of basically copyright superpowers in a way where they can do things that other institutions just simply cannot do for the purposes of preservation, for circulation, for my cat crawling on me and getting my allergies going. There's obviously the most salient example in a lot of cases is fair use, which is the First Amendment safety valve that exists on copyright law. Copyright law, if you're a constitutional scholar, raises a lot of serious First Amendment concerns because fundamentally copyright law is a restriction on how other people speak when that speech intersects with a pre-existing work. And so fair use is kind of a way that we've built in to say, like, look, there's plenty of ways that could theoretically be infringing, but just on a policy level, we're fine with them because they are critical to certain functions within a democratic republic. Things like news reporting, criticism, commentary, education, and on and on and on. And so when that becomes subordinated to this sort of digital framework that we have about, well, the first imperative is we need to maintain scarcity. And then after we've maintained scarcity, I guess we can maybe piggyback some of these existing uses. That becomes a real problem because all of a sudden you're asking very under-resourced institutions in a lot of cases to have to pick up all the slack of finding very complex technical solutions in a lot of cases to things that if they are not entirely clear that they are legally within their rights to do, they might be facing substantial penalties for doing it. So that you're asking under-financed institutions to take on both the financial cost and the legal risk of doing something that they're relatively sure that they are able to do and that they were able to do before this digital explosion, and they were able to do with physical media. But now because the book is an ebook rather than an actual paperback, it gets a little fuzzy whether or not they're okay doing it. And so, this move online, and I can go on at some length about it, but I don't want to sort of run through our time. Everything from online teaching. There are exemptions that allow teachers to show clips of movies, for example, in the classroom. Anybody who was in elementary school and remembers the thrill of seeing the big TV with the VCR get wheeled in to your sixth grade civics class remembers that particular part of copyright law. It's not clear if teachers can stream, especially even putting aside distance learning, which we're all doing now. If they wanted to stream something from Netflix or from Amazon, it's not entirely clear to some folks whether that exemption applies anymore. It is not clear, there's a very large fight going on right now about the ability of libraries to digitally lend ebooks and to loan ebooks specifically that were not created and licensed under a contract-driven permissions system made with the publishers. But to do ones that were basically sort of baked in-house and lent out more analogously to what libraries have always done, which is to lend out books on their own terms to a subset of people they define as patrons. And it's really shifted the control culture from the institutions down to the publishers, and it's concentrated the control of how these works are used in the hands of the publishers in a lot of cases. Live stream performances from DJs, instances of live stream performances of classical musicians on Facebook during the lockdown. People will sit down and try to play, concertos as a way to sort of ease the isolation of their followers. And they'll find out that Facebook shuts down their live stream halfway through, even though they are playing public domain music. And this is a problem with the algorithms more than anything. But in that case, you have a situation where classical music in particular is different recordings of classical music. The actual audio quality is almost impossible to distinguish uncopyrighted recordings from copyrighted ones, because the difference between different performances of the same classical piece are often very minute. They boil down to the sound quality of the room, maybe if you're a jazz piece, like a couple of notes in the improvisation section. And so an algorithm will see somebody doing it totally, it's their own, they're performing a public domain composition. They are not performing from any recording that is under copyright. But to an algorithm's ears, proverbial ears, it sounds very similar to a recording that is under copyright, and it will flag and take it And so we really have this kind of subordination of, frankly, common sense, to use the policy term, limitations and exceptions to the sort of overriding enforcement prerogative that has sprung up around digital media. Dan, I don't know if that's something you want to piggyback on?
Yeah, no, thank you so much, Meredith. I think there are, so many great points that Meredith touched on. But I think to begin, one of the biggest ones is that there is a very strange disconnect. So, when we're talking about physical books, there's an important clarification I should make. A physical copy of a book, that is rivalrous. Only one person can read it at a time. I guess you could squeeze in two people, but there's a finite number of people who can read it. Whereas with digital works, the sky truly is the limit with respect to how many people can consume it. So not just like the text is non-rivalrous, but at this point we're seeing that like the copies of it are non-rivalrous, and you can consume without harming another's ability to do it. So the way publishers and the rights holders industry has generally gotten around it is what some folks have called the end of ownership, where, I can own a CD or a physical copy of a book, and that is mine. I could give it to a library, I could set it on fire, I can do what I want, and I'm perfectly within compliance of copyright law. But if you have a Kindle, I don't care how, I don't need to know how many books you've purchased from Amazon to tell you that you own none of them. And so the way you get around it is that you have licensing arrangements where there's no actual transfer, and that's a significant reduction in the bargaining power of used bookstores, of libraries, of other institutions that rely on what's called first sale in order to transfer it. And that's a significant rebalancing of the power dynamic with respect to publishers. And I think the second issue that Meredith raised is really important as well, is that when we rely on algorithms to enforce copyright, a computer can only do what you tell it. They're actually quite dumb when you think about it. And in cases of fair use, where people are using content in a way that is perfectly fine under copyright law, but at the end of the day makes use of a medium, when that is taken down, perhaps erroneously, it's difficult for the person who uploads the video to go through the hassle of getting it restored. It may not be worth it. And the reason that that's particularly troubling, or as Meredith said, like you may be doing a public domain performance where fair use doesn't even apply because it's not protected by copyright, but because someone else has, a similar recording of the same composition, then it gets flagged. So in addition to just general efficiency issues and the fact that it's kind of problematic that in this particular sphere of policy, we actually view inefficiencies and frictions as a feature and not a bug. That's a curious issue. But finally, it's important to look at the perspective of the person who's at the mercy of, say, content ID or a DMCA takedown request, whether it's in bad faith or just it turns out the work is not infringing after all. Perhaps I am the rights holder and I have lost out on whatever pittance of a revenue that I would gain from a work that may or may not be infringing. But if I'm the YouTuber who's put that specific work in the context of something much larger that I put in significant effort to create, and then I get a copyright strike or whatever the internal functioning with the website is, or I have to comply with a takedown request, that's a huge burden on me. And I think that's a huge issue when that's sort of underappreciated when we're talking about it, is that these folks who rely on these works, who depend on fair use, they are also creators. And so, but this time the copyright laws work against them. So the way we think about it, the weird way we've created this legal fiction and translated into the digital world, this benefits older media models, yeah, sure, but I think it ignores the way the media landscape has evolved. And if we're going to have a copyright system that, unlike the patent system, doesn't make judgments of quality, for better or worse, if we're going to have it where it doesn't make judgments of quality, then we have to look and say like, oh, wow, there's a whole class of people producing creative works for whom copyright is at best inefficient. It doesn't really work for them, and at worst is an actual threat to their livelihood. So those are all sorts of problems that you run into. And then finally, as to what Meredith spoke at the top, you see in the fact that we're in the pandemic, we're moving into a weird legal space. The teacher can wheel in the video cart, and that's totally fine under copyright law. But can you stream it over the internet? They sound like exactly the same thing, but there's an ambiguity in copyright law that either hasn't really been anticipated or was simply ignored. And that's something that really needs to be addressed, or at the very least clarified. When you see publishers putting out a nice press release saying like, oh, we've decided to give free license for story time for the libraries to read it over, online. That's nice, but what they're really saying is like, we're kind enough to not sue you for what might be copyright infringement. So there's a weird inconsistency between doing something online, which is functionally the same as doing it in person, that copyright law hasn't really caught up with.
Yeah, so one of the interesting things, and I think as Dan very correctly pointed out, is that the pandemic has really thrown into stark relief the permissions culture that we've shifted to, rather than the legal regime necessarily. That, at the very minimum, publishers, and I use the term broadly, not just to refer to book publishers, but also record labels, music publishers, software, anybody, any rights holder sort of class, very much takes a very expansive vision of their rights, and has decided that we will defer enforcement for the time being. And that is the sort of benign neglect that a lot of consumers and educational institutions and whatever happen to live under right now. I do a lot of work actually with fandoms, so folks who write fan fiction, cosplay, all those kinds of things, and I constantly get questions about, well, is this legal under fair use? And I say, well, for the answer to fair use is maybe, but the functional exposure is that you live under a regime of benign neglect. Disney has decided that they're just not going to prosecute, guys making Captain America shields in their backyards because they think it's better for their bottom line. But legally, you have no certainty that that is not going to change tomorrow. And one of the most interesting embodiments of this idea towards permissions culture is that we now have a system through both a combination of the way the law is structured under the Digital Millennium Copyright Act, which was passed in 1998, so it's just past its 20th birthday. So sort of through the DMCA and through this sort of automated algorithmic enforcement mechanism, where it's very much skews towards the right. It puts near total control in some combination of the hands of the platform and the rights holder. And the impetus is generally take down first, ask questions later. The scope of the powers that are granted under the DMCA were something that may have looked proportionate back in 1998. Absolutely do not look proportionate in 2020, let alone pandemic 2020. So a couple of different things. One is, Dan talked about the economic impact of takedowns, which is crucially important, but also takedowns are used at length for non-copyright reasons. There is just sort of a raw free speech impact on free speech online from the abuse of these takedown notices. Keep in mind, takedown notices under the DMCA have a power that nothing else in the law, short of possibly an action by an intelligence agency, has, which is they are able to remove speech from the internet for up to 2 weeks, possibly longer, depending on how long the ping pong between the platform and the various parties takes. And it's the legal requirement is that speech disappears. That's the presumption against which you have to operate. If somebody receives if a platform receives a notice, the general presumption is that speech has got to go, no matter how good or bad that notice is, no matter how obviously malicious it is, it's got to go. So unsurprisingly, this is incredibly powerful. I think people fail to appreciate how insanely powerful this is. So it's very frequently used against political speech, is a favorite target. It's used against news reporting. You know, the Russian government is actually a prolific sender of DMCA takedown notices against news coverage highlighting its human rights abuses. The government of Ecuador as well has also been known to use the DMCA at length to take down reporting. You know, and especially if you're talking about news reporting, 14 days can be lethal to news reporting of developing situations. Imagine, you know, the mass protests that rocked the United States in the late spring and early summer. Imagine if we had a 14-day news blackout on some of the on-the-ground reporting about this. It would have been just catastrophic. And so I think people really need to appreciate the power of these notices. They're also used for anti-competitive purposes. You know, Amazon went on record back in 2016 and said, in Kindle Direct Marketplace, which is their self-publishing ebook marketplace, something like 50% of the notices that they received, the takedown notices for books in the Kindle Direct Marketplace, were from competing authors attempting to remove their rivals' books from the listings. Like, that's the scope of the problem we're talking about. So this is an incredibly powerful tool that, again, might have seemed proportionate when we operated in a world of GeoCities and like slightly later MySpace, but absolutely not today in the age of, you know, Amazon Direct Marketplace, or even frankly Twitter, where that's where a lot of folks get their breaking news, is through, you know, on the ground reporting done via Twitter. So there's that. You know, there's the stickier question about fair use. Is automated takedown basically shifts the presumption against the user in a case of fair use. Fair use is super fact intensive. There's no algorithm in the world that is going to be able to parse fair use. We just argued fair use at the Supreme Court yesterday in the Oracle Google case. That's how complicated it is. So there's no universe in which an algorithm is going to be able to determine that, just as a binary question. And I think the most gratuitous part of the DMCA that has aged very poorly, and this is the soapbox I get up on regularly, in 1998. So I'll preface this. Right now, the notice and takedown system that exists also partly applies to ISPs. So an ISP, if they receive sufficient notice of an accusation, I will be very specific here, there's no adjudication required. If a rights holder sends enough notices to an ISP saying, we accuse a user on your network of infringing copyright or using their connection to infringe copyright, that ISP must disconnect that user. Let that sink in for a second. That's not just disconnecting a user, that is functionally disconnecting an entire household. And, you know, for the some 100 million America, I don't even have the statistic on hand, that only have one broadband provider, that's disconnecting from the internet entirely. Part of this is because of the different roles that the internet plays today as it did in 1998. You know, obviously, you know, me sitting in my parents' house in 1998 using AOL dial-up to get to some forum message boards was one thing. Us having this webinar is a very different thing. You know, people attending school remotely in the time of a pandemic, totally different set of stakes. The other is actually a historical anachronism in what we term an ISP. So nowadays, an ISP, Internet Service Provider, is shorthand for a broadband provider. So an ISP provides two functions. One is they own the physical wire that connects to your house, you know, be that fiber, be that coax, whatever. And they also operate some of the software layer routing and connecting protocols. So there's a software layer where they take the traffic from coming up from your house, basically, they connect it to the broader internet and steer you where to go. But they also own the physical infrastructure. Back in 1998, an ISP was a software application. The ISP was America Online, was an ISP. It was a piece of software you ran on your computer, and the physical connection was the telephone network. And it was a telephone network. It was operated by a third party, which did not have any liability attached to it at any stage of the negotiations for the DMCA. Nobody ever suggested, as far as any of us can find, that maybe, you know, AT&T should be liable for copyright infringement happening on AOL if it happened to be traveling over their network. But because the business model of ISPs have collapsed those two functions into each other, being disconnected from the software layer necessarily now entails being disconnected from the physical infrastructure. And because broadband in competition in the United States is just frankly pretty abysmal, and most of the folks who have multiple ISPs, I can choose from two ISPs at least here in my home in suburban, Montgomery County, Maryland. And I live in a pretty, upper middle class, well-off neighborhood. People who live either in inner cities where there's digital redlining, there are whole neighborhoods that don't get decent broadband, or who live in very rural areas or areas with difficult geography where it's been difficult to roll out broadband. Those are the folks who can least afford to get disconnected. And they are the folks both in terms of they don't have an alternative and in terms of economically, this is their lifeline. And so it's created sort of double risk. And again, part of the larger discussions around, you've noticed I've had to testify on this twice in this last summer, modernizing the Digital Millennium Copyright Act. And that looks different for everybody. Everybody's got a different version. Everybody's got a different complaint about the DMCA. I got my own complaints, both about this and about Section 1201, which I don't know if you want to talk about after this, Dan, but and that's the anti-circumvention provisions that were passed basically as a horse trading trade-off to the notice and takedown provisions that we're talking about. Everybody's got a slightly different vision of this, but part of, if you've seen House Judiciary, Senate Judiciary IP Subcommittee has had hearings on this, basically on and off for a couple of years on the House side. And when we talk about that, part of that is just, you hear a lot of braying from content industry saying like, well, we can't keep up. It's whack-a-mole. We send a takedown notice, it comes back up again. And it is legitimately difficult, especially, I'm not concerned about Universal Music. I'm never going to be concerned about Universal Music or Sony. They have Scrooge McDuck pools full of money. They're fine. I'm concerned about independent artists who actually have to devote much of their time during the day to actually, they are the use case that is actually having the hardest time with this. And so, there's a separate rant about how I'm inherently wary of things like Content ID, which is the proprietary YouTube platform, which YouTube developed specifically to address its own specific economic and business model, and developed it in conjunction with the largest rights holders. And so it is very difficult to impossible to access for small artists. And it's gotten better, but it's still definitionally like designed to tip the favor and balance of rights holders every time. And specifically those large rights holders. But when you talk about this, like, it's amazing the degree of disconnect between the complaints of end users, the complaints of small businesses, the complaints of, as Dan noted, the sort of new creator class, which they're artists. They don't fit in the legacy business model. And so we've had to come up with sort of janky terminology to talk about them. And how everybody's got a different set of complaints. And so to the extent that we have this kind of rebalancing, I think it's gonna need to start taking a more granular view of who the folks actually involved are.
So Meredith, if I may just interject quickly with a question, and this also involves some of the work that Dan and I have done, but you've testified twice in front of Congress on the DMCA. What policy challenges arise when you're working with Congress and they have no tech background? Many of them just on average age are 55 and older. What kind of hurdles do you have in trying to explain some of the complex interactions that you've just laid out for us so nicely?
Yeah, so I mean, it's difficult. Staffers luckily are usually much younger. And so it's, then the staffer I get to offload the problem of explaining this to their boss, to the staffer. No, I mean, you genuinely, a longstanding problem in tech policy is this idea that when we are legislating solutions to problems, we are legislating specifically against Google and Facebook, and maybe Twitter, but the largest tech platforms, because those are the most salient ones. In a lot of cases for older lawmakers, those are the only ones they know about. Maybe sometimes they'll be aware of Wikipedia, but that's really the model that they have of the online ecosystem. And frankly, about to be 35, my model of the online ecosystem is wildly out of date in a lot of cases. I barely understand TikTok, but I've had to because all anybody wants to talk about. And so, you know, part of it is the difficulty of saying, no, there are small forums, there are fan fiction archives, like Archive of Our Own has been, the organization behind that has been very vocal in this whole process, which has been great. But explaining that, like, no, there are people who make their living through YouTube. You know, an 85-year-old lawmaker is probably not going to be following a whole lot of YouTubers. And they're definitely not going to understand that there are other platforms that allow for video streaming like Twitch that don't have the same model as YouTube and have different implications for how they operate. And the other is that, like, sort of as part of that, they are very familiar with legacy media structures. They're very familiar with, you know, to the extent that anybody who's not in the record industry is familiar with the record industry, that is the level at which they kind of like, okay, I understand this. And they are familiar with older artists. And so there is often, you see this every time we have a big hearing. You know, I testified on the Music Modernization Act back in 2018, and like Smokey Robinson was there, as well as a lot of older legacy artists. And that's because that is a point of connection for older lawmakers. And so they're like, aha, well, Smokey Robinson is saying that I should do this thing, and that's great. And then I have to come in and argue why YouTubers are just as important in this equation. That's an uphill battle. So it is a challenge. The other is that fundamentally, the way tech policy, the way copyright specifically, and this is part of a broader tech policy issue, but the way it's always been framed really as going actually, it's not even fair to say from the DMCA onward, going all the way back, is as a fight between industries. If you have not read, Jessica Littman did a wonderful book called Digital Copyright, and it traces basically the history of the industry horse trading from the early 20th century up till today, of how the Copyright Act shaked out the way that it did. It's this history of, you know, you have some incumbent industries, and then you have some newcomer who's not statutorily in the scheme yet, and they come and mess everything up. And then, you know, the legacy industries raise hell, and then there's a like wrangling for several decades sometimes, and then the newcomers get incorporated into the statutory framework. And then you lather, rinse, repeat, just on and on and on. But consumers have never really been part of this model, and that made some degree of sense, you know, really up until you get to like home taping issues. You didn't have the risk of, under the statute, what amounts to the possibility of having copyright infringement on a mass scale. You know, you're concerned about like organized crime doing mass bootleg cassette tapes. You weren't concerned about, not everybody had access to the kinds of, you know, machinery you needed to do that. Nowadays, we all have supercomputers in our pockets. And also we are reliant on the same thing that we are regulating in order to conduct our entire lives. We are reliant on the internet to just live nowadays. You can't even apply for jobs without an internet connection. And so we are at a point where they can't avoid that anymore, but breaking that myth that this is a fight between big tech and big content is a really hard thing to break. It's an extremely difficult schema to say, like, no, there are consumer groups, and there are groups of small artists who have distinct interests and have been independently voicing these interests. You know, we saw the Copyright Office just did a report on Section 512, which is the section that, among other things, has the notice and takedown provisions. And that report was, I think, literally like close to 5 years in the making. It was a very long time coming. Because everything is shifting all the time, they released that. And one of the things that was most frustrating to me as a consumer advocate is that they lumped they basically said, well, these consumer concerns are really not distinguishable from platform concerns. To which I, you know, stood up and shouted and threw all of the white papers in their direction. You know, we absolutely have distinct concerns. Like, we don't like consolidated platforms any more than anybody else. When we talk about, you know, a world where we don't want everything to be Twitch and YouTube, I very sincerely mean that. I don't want everything to fall under the umbrella of Amazon and Google. I don't want streaming music to have to be a loss leader for a more profitable, you know, massive tech conglomerate. I think that's a really unhealthy state for the market to be in. And breaking that myth that archetype of this is two giants at war with each other is very, very difficult. And there have been some great efforts by artist groups, especially small artist groups, to work on that. And also, frankly, just bringing basic economics to some of these industries. Being able to talk about the economics of music licensing is so wildly complex. It's very difficult. First off, it's hard because there's no public information on most of the stuff. Contracts, because you're dealing with an industry that at the end of the day deals with a bunch of independent contractors. And so all of the values being generated by these like little independent actors who sometimes can communicate with each other, a lot of the times can't. Contracts are under non-disclosure agreements, so it's very difficult to get any kind of 30,000-foot view of what's going on. And so the only person who holds all the information on this is the publisher or the record label, and you just have to kind of take them at their word, which is a very risky proposition for anybody, let alone lawmakers. So it's a complicated kind of mess. And of course, you know, the economics of the recording industry are different from the economics of the music publishing industry, which are different than the economics of the live music industry, which are wildly different from the movie business, from software. You know, all of these require individualized thinking. And that data is just incredibly hard to get by.
Yeah, that's excellent. So with respect to sort of my observations, like what are the problems to reform, picking up on what Meredith mentioned, I think there is, and this isn't necessarily an age issue, this is just kind of like the obvious question you have to ask with respect to copyright, or rather this is the obvious objection, is that, but if we don't guarantee exclusivity, both legally and in practice enforce it, then there won't be incentives to create. And the problem with this argument is that it's very open-ended and it can just be asserted to justify, indefinite copyright terms would be unconstitutional, but you could just say like, you know, what's the Jack Valenti line, forever minus a day, as the copyright term. Like you can justify pretty much anything under that. And of course there are issues where rights holders, publishers, everything like that keep the information necessary to really figure out, well, let's see, like, how are you folks doing? Can we handle perhaps a scheme like controlled digital lending where you can have a physical book and then make it readable online? It's essentially moving a library online. And, you know, every book I check out from the library maybe prevents me from purchasing a book, but we're okay with that. So why can't we expand it? Oh, well, we can't because then we won't have incentives to create this, that, and the other thing. And the problem is that you can just assert it at you know, any number of times, and it's really difficult to challenge because a lot of the data are proprietary. So that's the big issue. I think the second issue is that there is an opportunity cost. So for example, there was a profile in the New York Times a couple weeks ago that talked about Random House and how they're doing fairly well in the pandemic because, you know, well, after Tiger King, what was there left on Netflix? But one of the things they talk about is that they rely quite heavily on legacy publishing older works, and the copyright terms that we have, like 70 or 95 years, are just ridiculous. Like I just call nonsense on them. And the issue is, if you can rely on an older asset that is in high demand to just keep making money, well, that means you've got like a really solid business plan, and that means you're not investing in new works that, to be fair, may fail, may turn out to be duds. But that's not a particularly good policy design where we encourage the collection of passive income that does not come from productive investment. So it's not just the question of that, oh, you know, it's open-ended, you can justify almost any copyright policy by just saying incentives to innovate, but there's an opportunity cost issue. There's a real problem associated with that. In addition to there, it prevents a certain degree of innovation. Meredith talked a lot about how, you know, major record studios and Disney, like these folks will be fine. They can handle, you know, these larger automated content systems. But for smaller creators, that is an issue. You know, access to content ID is a problem. You do run into a whack-a-mole scenario, but the issue there is that I think focusing so narrowly on copyright law specifically as the instrument distracts from a more productive conversation about, well, how can we design a system where inefficiencies and frictions are not a load-bearing feature of it, where this is a desirable thing. You know, we talked about the new creator model. There are plenty of folks for whom copyright just like doesn't make sense. Like if you have a Patreon, you benefit from people being able to see it. And so exclusivity doesn't make any sense at all. And that's not to say that it works, that, you know, this necessarily works for all different types of creators, the producers of works, but you have this very specific focus on copyright law as the only way in order to guarantee a return. And I just don't think that's true. And I think we're stuck in a very 18th century mindset. You know, there's a line that was frequently spoken in the DMCA hearings, you know, DMCA is a MySpace law for a TikTok age. Well, to be pedantic, it's a Google law for a Google age. MySpace was created in 2003. But more specifically, like if we're going to pick at the DMCA for being 22 years old, well, our copyright laws date back to the Statute of Anne at the beginning of the 18th century. So, you know, don't look behind this 18th century curtain, I think is concerning. And I think the last issue, if we're talking about the need to enforce copyright and view that, you know, every unauthorized use, whether or not it's fair, as this, you know, horrible thing which must be prevented. As Meredith discussed, there is a technological problem. You know, you get kind of the nerd harder debate where people say, you know, you can count the number of likes and retweets and this, that, and the other thing. Why can't they find infringing content? And that that argument makes sense purely on a rhetorical level. But if you scratch the surface, it doesn't really work. If you're talking about just clear piracy, like uploading full episodes or full songs or whatever to you know, whatever site, then yeah, it works fairly well. But for fair use, computers are or algorithms are terrible at figuring that out. So not just is there you can't just say nerd harder and then all of a sudden we'll get perfect copyright enforcement, but you also have to be concerned about the false positives I mentioned earlier. You know, you lose out on the royalties from that song, but I get a copyright strike on my channel, and that's a very direct threat to my livelihood. So I think those are the major impediments to progress when we're talking about copyright.
Well, one of the things that struck me just now when you were talking, Daniel, about the fact that copyright law is early 18th century, and that even the DMCA is 22 years old and already really confronting such a rapidly evolving landscape that it's struggling to keep up. Clearly, there's a lot of complexity in these issues, and it has been an absolute pleasure to listen to both of you who clearly have a full grasp of all the ins and outs of not only the subject matter, but how the subject matter interacts. And I'm not seeing any questions in the chat. And I certainly don't want to cut us off early, but being respectful of everyone's time, I have really appreciated this conversation. Part of my favorite aspect of working at a think tank is the opportunity to learn constantly. In fact, my laptop for today's webinar is actually propped up on my property rights law textbook. So I feel like it's particularly fitting. And thank you to everyone who attended the conversation. Before I close this out, I will give Daniel and Meredith one opportunity that if there's any additional resources, any papers that you've written recently, any websites or resources that our attendees should be aware of, please unmute yourselves and let the attendees know.
Sure. A couple of things, you know, my employer, Public Knowledge, we engage in a lot of these issues and a lot of related ones. The thing is, I think when we think about, especially things like notice and takedown, they tend to get tied into issues like content moderation or, you know, exclusivity in app stores even sometimes comes up, misinformation questions. So, you know, we've published a lot of things on this. My colleague, John Bergmeyer, if you're interested in app stores, published a pretty extensive white paper called Tending the Garden, which talked about the competitive aspects of app stores. My colleague Harold Feld put out a little light beach reading of a book calling for a sort of outlining the case for a digital platform act, which I believe is the title. And I'm sorry, Harold, if you're watching this and I got it wrong. but sort of outlining here are the various unique problems to digital platforms and how maybe we need to start thinking about them more holistically. There's a whole lot. A colleague John Bergmeyer again put out a different one a little while ago on content moderation called Even Under Kind Masters, which talks about the sort of the stakes of getting content moderation right and what folks need to think about. And we just blog about all of this constantly. So highly encourage folks to follow the PK blog and the PK Twitter feed. We're a bit of a policy magpie, so if there's something cool, we're probably going to try to talk about it.
That's wonderful. Thank you, Meredith. And what about you, Daniel?
Sure. So, of course, be sure to look at the niskanancenter.org website and follow online. I manage capturedeconomy.com, which is where we cover these issues on intellectual property with a focus on rent seeking and regressive regulation. Late last year, my colleague Brink Lindsay and I also wrote a paper called Why Intellectual Property is a Misnomer. And the title kind of says it all. But I think it is particularly important when we talk, back at the top of the hour, we talk about it, that we recognize that there are important implications. If it were property, that would change the calculus significantly. And for folks who do believe it is property, that does inform the calculus. But when we look down into just the nature of ideal objects, the nature of the incentives to create, property doesn't really fit. And so we need to keep that in mind with respect to crafting policy. And also on the website, capturedeconomy.com, the focus is on the pursuit of above normal profits called rents. If you're a fancy pants economist, and how that is unnecessary to bring these into production, and how the laws create that, which again goes back to the point of you can justify any copyright law you want just by saying there won't be incentives to create. And so we do our best to dig into the issues and say how this industry is doing well, doing well. They are pushing for policies that disproportionately benefit them at the expense of their competitors, or this is a policy which by its design doesn't encourage, doesn't promote the progress of science and the useful arts, to quote the Constitution, in the way that we would like.
Well, thank you both. And I have to admit that Daniel just brought up our colleague, Brink Lindsay, who's a vice president in a Niskanen Center and heavily involved in the Captured Economy project. And unfortunately, Brink couldn't be with us today, but his books are available on Open Library, and he's a very big fan of that platform as well. So thank you to all our attendees. Thank you to our panelists. I learned a lot. I hope you did too. And I hope that everyone has a wonderful afternoon.